Welcome to the regularly scheduled meeting of the Community Development and Regulatory Services Committee for today, February 25th. I've been joined by council members Warsami, Reich, and Fry, which is a quorum of the committee. We have a relatively brief agenda today. We'll start with the consent agenda, which starts with item number 6 and moves all the way through item number 18. Are there any items 6 through 18 that anyone would like to pull for discussion? Seeing none, I'll move the consent agenda, items 6 through 18. All in favor signify by saying aye.
Aye.
Any opposed? Those items are approved. If you were here for one of those items, they will not be heard then in committee today. They've already been approved. We'll then move to item number 1, which is our public hearing. Ms. Shoquist, welcome.
Chair Goodman, council members. I'm Sherry Shoquist from Community Planning and Economic Development Housing, and I'm here before you today to request your approval of the Green Homes North Program Round 3 funding awards and the land sale public hearing. We are requesting an approval of a recommendation to award up to $1.13 million for development gap funding for the construction of 20 homes on city-owned vacant lots in North Minneapolis. This is in addition to the nearly $420,000 in land assembly that was put into these properties before they became part of the Green Homes North program. And I am going to quickly, hopefully in 5 minutes or less, go through the history of the program and some of the homes that we are funding. There are 3 goals for Green Homes North. In addition to building 100 green energy efficient homes to boost the confidence of the North Minneapolis housing market, to assist in other homes in the neighborhood gaining value and having higher appraisals, we are also working to create job opportunities for local residents and minority and women-owned businesses, putting North Minneapolis and Minneapolis residents to work in constructing these houses and promoting Minneapolis businesses that provide green housing products. So we have a triple bang for your buck with this housing program. Our funders, in addition to the City of Minneapolis, our Minnesota Housing, Family Housing Fund, and the Twin Cities Community Land Bank provides very low interest loans for these properties. Here you have a map of the Round 3 locations, which was part of your packet and is available on the city's website. The developers are developers that are familiar to the City Council, Project for Pride in Living, City of Lakes Community Land Trust, Greater Metropolitan Housing Corporation, Habitat for Humanity Twin Cities, PRG Inc., Pazer LLC, who's our one private developer, and Urban Homeworks and Art Space. Both the City of Lakes Community Land Trust and Urban Homeworks are new to this funding round. Most of the homes that I'm going to quickly go through are 3 bedrooms, 2.5 to 3 baths. They are at a range of square footage from 1,400 to closer to 1,800. Many of these homes will be built in the Hawthorne Eco Village, expanding on our cluster concept in that neighborhood. So this is PPL in Willard Hay, another PPL in Hawthorne, PPL in Hawthorne. This is one of the 2 City of Lakes Community Land Trusts, which is true universal design in providing 4 bedrooms and 2.5 baths with the option to have a separate unit for families with larger cross-generational families. This is one of the gimmick designs in McKinley, another gimmick in McKinley, a new gimmick design in the Jordan neighborhood. This is a Habitat design, Jordan, also Habitat in Jordan, Habitat in McKinley. This is the PRG home that's in near North. PRG in Jordan, the same home in Hawthorne. This is the Pazer home that will be in Cleveland and also Weber Camden. This is the new Urban Homeworks home that will be in Hawthorne. And this is the art space home that will be in Willard Hay. I wanted to quickly show you the Pazer home. This is the finished product, our first Green Homes North home to be completed. One has sold, the other is set to sell this later this week at over $200,000 per home. And here's a quick look of the interior design and finishing. And this is the Habitat for Humanity Net Zero home that we're also very proud of. I direct you to our city website to see pictures of all of the Green Homes North homes, the 27 that are in process. And I thank you for your consideration and would be pleased to take any questions.
So I had asked for you to give us a sense of what the land cost contribution was from the city's end of it that's in addition to the development subsidy?
Right. So in addition to the $1.13 million in development gap funding, there is additionally $420,000 that is land assembly.
Okay, so I just want to make sure staff note that is money out of pocket from the city that should be allocated towards the total amount of money we're spending on this project, as well as investment in housing in North Minneapolis. Just want to make sure that's noted because it's not in the report and it is cash out of hand from the city. Further comments or questions before we open the public hearing from anyone on the committee? Seeing none, I'll open the public hearing on item number 1 and ask the clerk, would you like me to read out loud all of the addresses? It's like a quiz. Okay. This is a public hearing on item number 1, which is including the land sales at 2014 Upton Avenue North, 2950 Bryant Avenue North, 316 30th Avenue North, 4700 Bryant Avenue North, 4704 Bryant Avenue North, 3510 Colfax Avenue North, 3514 Colfax Avenue North, 2635 James Avenue North, 3022 Morgan Avenue North, 2918 Logan Avenue North, 3522 4th Street North, 1811 Girard Avenue North, 2727 3rd Street North, 2639 James Avenue North, 3241 Russell Avenue North, 4101 James Avenue North, 2822 Bryant Avenue North, 2901 Bryant Avenue North, 2622 Plymouth Avenue North, and 1352 Thomas Avenue North. If there's anyone here to speak to any of these land sales, please feel free to step forward and state your name and address for the record. Anyone? Anyone? Seeing none, I will close the public hearing and call on Councilmember Reich.
Madam Chair, I happily move the item before us.
So Councilmember Reich has moved approval. Is there an alternative recommendation, or we're just going to move forward provided that the Family Housing Fund puts in the contribution that has been anticipated in this report?
That is correct. Thank you for clarifying that.
Okay. So just to clarify, all of the items in front of us as recommended by staff are moved for approval on the condition that all of the funders listed in the staff report come through with their portion of the contribution towards this larger effort. Is that clear? Okay. Further comments or questions on that motion? Seeing none, all in favor signify by saying aye.
Aye.
Any opposed? Those items are approved.
Thank you.
We'll then move on to item number 2. Mr. Wilson.
Thank you, Madam Chair. Item number 2 relates to an application by Soul Sisters Incorporated, doing business as the Hen House Eatery at 730 2nd Avenue South, the former Peter's Grill restaurant site. They are seeking an on-sale liquor Class E with Sunday sales and sidewalk cafe license. The applicants are Barbara Gardner, Tara Koning, Maria Peralt, are all been in the food industry for a long time in the local area. This restaurant will have interior seating for 260 patrons and sidewalk cafe seating for 75 persons. This site has not had alcohol on it before, and so a public hearing is required. We did mail 83 notices to property owners and residences and neighborhood associations and business groups. We did not receive any responses for or against this application, and staff indicates that they meet all of the requirements, and we recommend approval.
Are there any questions for Mr. Wilson on item number 2? Seeing none, this is a public hearing on item number 2, which is consideration of an on-sale Class E with Sunday sales and sidewalk cafe license. Is there anyone here to speak to this issue? Anyone? Anyone? Seeing none, I'll close the public hearing and move approval myself. I assume you three ladies are the applicants, and I just want to congratulate you for this awesome idea. As someone who's lived downtown for a long time, breakfast is really hard to get, and I just think you're going to breathe new life into this Peter's Grill space and make lemonade out of lemons when Peter's Grill closed. And then to see so many young women being so entrepreneurial and getting involved in the restaurant business, I'm just really proud you're doing it and congratulate you. On the motion to approve the staff recommendation of issuing the license, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. Thank you for being here today. We're just going to take our one other non-quasi judicial hearing, which is item number 5. First, so our staff don't have to wait through the quasi-judicial public hearings. And this is a joint consent item with the Minneapolis Community Development Agency as well as the Community Development Committee. I just want to see if there are any questions. I know we have staff here if there are any questions. If they're not, it would be a consent item and we don't need to have a report. Are there questions on item number 5? Seeing none, I'll move approval of item number 5 and thank staff for their long and laborious work on getting to this point. I thought it was ironic that we were being asked to approve the change in name. They better have a good PR firm to change the name of Block E to something else, but I offer them good luck in trying. On the motion to approve the staff recommendation, all in favor signify by saying aye.
Aye.
Any opposed? That item is approved. Now we're going to move on to our quasi-judicial public hearings. Councilmember Fry.
Thank you. This is item number 3 in regards to Champion Salon and Eatery, Saloon and Eatery, 105 West Lake Street. I'd like to call on Grant Wilson and Joel Fuzzy.
Thank you, Madam Chair and committee members. Item number 3 on today's agenda relates to a Class E on-sale liquor license renewal that is pending for Star Mac Incorporated, doing business as Champion Saloon and Eatery at 105 West Lake Street. Notice of today's hearing was provided to the licensee and their legal counsel on February 10th of 2014. Due to a series of events that occurred at this establishment in the last few years, a notice of adverse license action was issued to the licensee in October of 2012. The licensee and the city of Minneapolis agreed to have this matter heard by an administrative law judge, and the hearing commenced October 7th of 2013. The details of this matter and that hearing are contained in the findings of fact, conclusions, and recommendations attached to today's agenda, and also within a case history evidence document file that has been deposited with the city clerk. The administrative law judge in this case finds that the renewal of the subject liquor license would not be in the public interest and recommends that the Minneapolis City Council exercise its authority and discretion and not renew this on-sale liquor license. Staff is recommending that you adopt the findings of fact, conclusions, and recommendations of the administrative law judge, and further recommend that you deny the license renewal of the Class E license held by Star Mac Incorporated.
Before we get into the findings of fact, I just wanted to outline that this is a quasi-judicial business license hearing for which this committee is limited by law to hearing argument from the licensee or the licensee representative, but is prohibited from considering any further evidence or taking any further testimony. This means that the parties are required to limit their comments to arguments specifically addressing the evidence or testimony introduced before the ALJ, which is part of the record that is already before us. You may not offer and may not consider any new or additional evidence. The committee has reviewed the report and recommendation of the ALJ and any written exceptions filed by the parties and has been provided with the official record of the administrative hearing. Based solely on this official record and the arguments that the parties make today, the City Council may affirm, modify, or reverse the recommendation that is before us. So in other words, there's the facts that can be presented today are limited to what's already been presented by the administrative law judge, and I'm now looking to Mr. Fussy to take over and give us the rundown on the findings and facts.
Thank you, Mr. Vice Chair and committee members, and for the purpose purposes of the record, I'm Joel Fussy, Assistant Minneapolis City Attorney. It was my role and also my privilege to represent the city staff in this matter, inclusive of Mr. Wilson and his business licensing staff, as well as the Minneapolis Police Department over the course of many months and throughout the extensive proceedings of this case. The matter was heard by Administrative Law Judge Jeannie Cochran of the Minnesota Office of Administrative Hearings during the course of the week-long evidentiary hearing that Mr. Wilson referenced. In the months following the hearing, extensive post-hearing briefing and written closing arguments were submitted by both parties, and Judge Cochran issued her determination on February 6th of this year, and it is this nearly 40-page report and recommendation which is before you today for consideration. I submit on behalf of the Business Licensing Division and the Minneapolis Police Department that the report is extensively detailed, thoroughly structured, documented, and cited, extremely well-reasoned, and altogether fair, accurate, neutral, and professional. Therefore, it's the request of city staff that you adopt and incorporate this report in its entirety, which concludes that renewal of Champion's liquor license would not be in the public interest, and move to deny renewal of Champion's operating license. I'll focus my remaining brief remarks on the specifics of the report which is before you and highlight some of the primary areas which, taken as a cumulative whole, overwhelmingly support the well-reasoned conclusion that city staff and Judge Cochran have now both reached, namely that continued renewal of Champion's license would not serve the public interest and that an adequate basis exists from which to deny such renewal. Importantly, however, for reasons of brevity, I will only touch upon a small sampling of the incidents and circumstances that support this conclusion, as the report as a whole goes into much greater detail regarding the incidents which I will highlight, as well as the numerous other aspects which I will not touch upon today. First of all, the report establishes that Champions has been subject to progressive licensing action and that the bar previously was a subject of serious and rare license actions in 2006 and 2007, in which it admitted to numerous violations involving illicit narcotics transactions occurring on its premises. These license actions resulted in the bar entering into settlement agreements with the city in which it served license suspension periods, paid fines, and agreed to various licensing conditions. The signed agreements also put the bar on specific notice that further violations could result in denial of its license. In early 2011, now Assistant Chief Matt Clark took over as inspector of the 5th Precinct and received information and data that indicated that narcotics and gang-related activity was becoming prevalent at and immediately surrounding Champions. Throughout the course of an operation that lasted from September of 11 through January of 12, numerous instances occurred in which illicit narcotic sales took place in or on Champions premises. Most of these instances resulted in arrest, prosecutions, and felony-level criminal convictions for the drug offenses. Even after the operation concluded in January of 2012 and was publicized in the media, additional narcotics-related violations occurred in or on Champions premises as detailed in the ALJ report. Although portions of some of these drug transactions took place just off of Champion's premises, all transactions involved aspects, whether it was the exchange of money or the retrieval of drugs or the solicitation or agreement to the transaction, that took place on the actual premises. And the ALJ specifically delineates in her report that her recommendation is not founded in any manner on any activity that took place off of the physical premises of the establishment. On at least 2 occasions, narcotics-trained Minneapolis police officers observed open marijuana smoking on Champion's premises or the clear indicia of such smoking. In one of the incidents, an undercover officer smelled a strong odor of marijuana smoke and subsequently observed marijuana smoking and, in fact, was offered marijuana at a table that she was seated at within close proximity of bar security. In another incident, an experienced narcotics officer conducted a walkthrough of the bar after receiving reports of drug use in the bar and detected a heavy cloud of marijuana smoke, indicating more than one person smoking marijuana within the bar. As pointed out by the ALJ, the licensee's, quite frankly, incredulous defense that the smell was some sort of contact derivative smell emanating from customers' clothing who had smoked marijuana prior to entering the bar leads to a conclusion that the licensee must pick its poison, so to speak. Either extensive marijuana smoking was occurring within the bar, or bar security was permitting individuals who reeked of marijuana smoke to enter the bar. Furthermore, at least 3 individuals employed by Champions confirmed marijuana smoking on the premises of Champions as detailed in the ALJ report and the hearing record. The report also details multiple instances in which Champions was operating outside of its license class by offering entertainment that would require a more expensive and more intensive license classification, as well as multiple instances of violent activity, including assaults, large fights, shootings, and eventually a homicide committed with a firearm inside the crowded bar that all occurred in or on the premises of Champions. The ALJ's report also details security deficiencies contributing to some of these incidents, including overservice and admittance or readmittance of individuals involved in drug activity or violence. Finally, in December of 2012, the chief of security for Champions solicited an undercover Minneapolis police officer for prostitution while inside Champions. The chief of security was charged with and convicted of a gross misdemeanor prostitution offense and admitted at hearing to making the solicitations, which were audio recorded by the police. Despite the licensee's knowledge of this incident, the chief of security remained employed by the license holder for over 3 months after the incident. Based on this extensive history, the Business Licensing Division of the city, along with the police department, continues to strongly recommend that renewal of Champions liquor license would not serve the public interest and that it should therefore be denied. After the extensive administrative process, Judge Cochran has now joined that recommendation and concluded that a legal basis has been demonstrated by the city to support such a denial. Such recommendation is based on the progressive licensing history of the establishment, the extensive and wide-ranging criminal and nuisance activity that has occurred on the premises, and which has been unable to be prevented by whatever security measures the licensee has instituted. The law recognizes that the holding of a liquor license is a highly regulated privilege and not a right or a property interest. The law also recognizes that it is the affirmative responsibility of a liquor license holder to prevent criminal and nuisance activity on its premises, and that it is most decidedly not the responsibility of the city or the police to do so on behalf of the licensee. The ongoing, extensive, and serious nature of the activity that has continued to occur through the years at Champions conclusively demonstrates that the responsibilities that attach to the holding of a liquor license in the city of Minneapolis have not been fulfilled by this license holder. Whether that has occurred through circumstance, neglect, or abuse of the privilege of holding such a license might be debated by the license holder, but what cannot be seriously debated is the unmistakable conclusion that the operation of this bar has not served the public interest and that renewal of its license would not serve the public interest. Therefore, the Business Licensing Division and the Minneapolis Police Department respectively request that you join this conclusion, which has been affirmed and recommended by Administrative Law Judge Cochran in her well-reasoned report, by means of adopting the judge's report and denying renewal of the subject business license. Thank you for your time and consideration.
Thank you, Mr. Fuss. Just a few questions regarding the specifics. First off, it's my understanding that the present owner of the bar is Rick Nelson. Do you know when he took over as owner?
He was involved with the bar, as the report goes into detail, for many years and was present at the license settlement hearings in 2006 and 2007. I think he became the sole owner of the bar, I believe, in 2008 is what the record reflects.
Okay, so there was a settlement conference in 2006. What then prompted an additional conference in 2007?
I believe, as the record would reflect, that would be a reoccurrence of some of the similar type of ongoing narcotics activity.
You said similar. Were they the same or were they different?
Well, they were new events and new violations.
New events that violated the previous settlement agreement?
Correct.
Okay. And you mentioned that the chief of security was charged and convicted for the solicitation of prostitution. Can you give me the rundown on what happened there specifically?
Well, as I think the record reflects, there was an undercover operation targeting the drug activity in the bar that night. The chief of security was present in the bar and struck up a conversation with one of the undercover officers. The officers were trying to get rid of him because they were engaged in trying to fulfill a separate drug buy, and he was persistent enough and eventually made very incriminating statements that were audio recorded, to the point where, even though the police officers didn't want to be distracted with that event and wanted to fulfill their purpose for being there in terms of the drug activity, they felt compelled to enforce the law at that time and arrested him for that violation. He subsequently did plead guilty to that violation. It was an Alford plea, however, that does still count as a criminal conviction in the state of Minnesota, and he did admit at hearing to making the specific incriminating statements that were audio recorded and which are referenced in the report. And for means of decorum, I won't repeat what those were.
Thank you, Mr. Fuss. Do we have any further questions for our attorney? I'd like to ask hear from the licensee and or the licensee's attorney. Mr. Fuss, we may have further questions for you later. Good afternoon.
Good afternoon, Mr. Chairman and council members. My name is Ed Matthews. I'm the attorney representing Champions in this matter.
Mr. Matthews, just before you get started, I'm thinking 10 minutes plus in that range. So I think just
Got a little bit more than that.
well, you can give a little bit more than that, but we're not looking at 20.
Mr. Nelson is present here today. This is obviously a very important matter, both for him and for Champions. Champions employs 25 people and pays nearly $100,000 in sales tax to the city of Minneapolis. And since Mr. Nelson has been in control of Champions in 2008, the pull tab operation has resulted in over $2 million being donated to the Incarnation Church food shelf. This is a very important matter. This is unlike the matters that just came before the committee, and I ask some indulgence for me to tell the rest of the story because I think you're getting snippets of it, and quite frankly, Administrative Law Judge Gene Cochran missed several key pieces of evidence, and I'm going to highlight those today, and I'll
Councilmember Goodman.
Councilmember Fry, you are only allowed to repeat what's in the record. And
Right.
we have the record. So
Yep.
if there's more story, we have the record. There can't be any more story than the story that's in the record.
I agree, and I'm going to highlight key points that are in the record that were omitted from Mr. Fussy's narrative.
Sure.
Yeah,
I just want to make it clear that we have the record. We've all read it extensively, and you don't need to repeat to us what we've already read, assuming that we didn't read it. I bet everyone here, it's a big issue, everyone here has been through it with a fine-tooth comb.
I can assure you that I'm not going to go outside the record. What I will share with you is during the 2006 and 2007 licensing actions, Mr. Nelson was merely a 10% owner of Champions. An individual by the name of Mr. McNamee was in control of the company back then. Mr. Nelson did not obtain full control of Champions until 2008. At that time, he implemented extensive security measures which are outlined in the record. Better security personnel, 14 cameras, trespass lists, walkie-talkies, metal detectors. This is all in the record. Mr. Nelson, and these are Exhibits A and B. Mr. Nelson became concerned, however, that the bus stop right outside of Champions was being used by gang members and drug dealers. In June of 2011, and this is Exhibit G in the record, Mr. Nelson wrote a very detailed email, and I won't read it, to his council member, Meg Tuthill, outlining his concerns about the bus stop outside of his business, and he asked that that bus stop be moved. The next document that we have in the record is Exhibit H, which is an indication from Sarah Metcalf, a sergeant with the Minneapolis Police Department, that her inspector, then Inspector Clark, wanted to get some crack buys out of the bar. So instead of working with Mr. Nelson on his concerns and addressing the bus stop issue, and by the way, the administrative law judge has recommended in her findings that this bus stop that is the true problem, that is the true problem. She has recommended that that bus stop be moved, and if it had been moved back in 2011, we probably would not be here by now. But instead of working on the root cause, the city chose instead, Mr. Wilson and Inspector Clark chose to target Champions. And we had this undercover operation. And in several of the exhibits, we had suspects that were telling the police officers that they did not want to do drug deals anywhere near Champions because they were aware of Champions' extensive security measures. Exhibit 10, we continued walking to the southwest corner of Lake and Blaisdell to the bus shelter. Drew, the suspect, told me there were cameras in the back lot of Champions and told me to follow him further down Blaisdell. Exhibit 11, Aaron Anton Davis was off Blaisdell Avenue. I met with Davis on the east side of Champions on the sidewalk. Davis told me he was 86th. 86 means he had been trespassed. He had been 86 from Champions and led me to the bus shelter. That's where the deal was done. Exhibit 13, Duke told me to keep walking. Duke stated, no, I can't do it here. The bar has cameras. And the record goes on and on. Exhibit 17. Exhibit 26. And Exhibit 28 is quite telling. There was an officer by the name of Jonas Novak. He was not part of the regular undercover operation. He was there pursuant to a career enrichment assignment. Here's what he had to say. I entered the listed location at approximately 2200 hours, and was searched for weapons by Champion's bar security at the front door. I observed bar security approximately 3 to 4, being very diligent and observant to bar activity inside and outside the bar. S1 asked for a cigarette and continued talking to me about how security at the bar was on point and don't F around. Throughout the evening, I observed bar staff security ejecting patrons who were causing problems. Council members, the record demonstrates that Champions has extensive security, and for that reason, the undercover operation was not successful in getting crack buys out of the bar. Because the security was so extensive, the drug transactions had to be conducted elsewhere. The record is replete with situations where the drug dealers were aware of the security and chose to do the transactions elsewhere. We are very concerned, council members, that Champions has been targeted like Gabby's was targeted, because Champions caters to a predominantly African American clientele, and that they have been set up for failure. They've been targeted by the licensing department, when it was in fact Mr. Nelson in the first instance that brought the root cause, the bus stop, to the city's attention. And instead of addressing the root cause, this undercover operation was launched. When Matt Clark announced the results of this undercover operation, he went to great lengths to tie it to Champions. He didn't talk about the bus stop in his press release, and this is all in the record. He tied it to Champions, and quite frankly, that was inappropriate. As he was doing that, as Inspector Clark was doing that, he forbid off-duty officers from working at Champions. One of the security measures that Mr. Nelson implemented when he took over as full owner of Champions in 2008 was having off-duty security officers work there on Wednesdays, Fridays, and Saturday nights, on its busiest nights. Inspector Clark, for reasons known only to him, forbid off-duty police officers from working at Champions. And by any analysis, the forbidding of off-duty officers from working somewhere can only serve to weaken the security situation. And that is further evidence that the bar has been targeted and has been set up for failure. Mr. Nelson served in the military police during the Cold War. He is very respectful and appreciative of good security. He runs a tight ship. He is doing all he can on what, by all accounts, is a very difficult corner, and what continues to be a very difficult corner, while that bus stop is located at the corner of Lake and Blaisdell. There is no reason to deny there's no reason to non-renew Champions liquor license. There have been no violations committed by Mr. Nelson or Champions. I'll address briefly this solicitation of prostitution allegation. Mr. Randall was there on a night when he was not working. His side of the story was he was trying to make sure that there was not a prostitute in the bar and engage the person in conversation. That's his story. I wasn't there. I don't know what happened. Mr. Nelson gave Mr. Randall an opportunity to have his side of the story heard in court a few months after the incident. Once it became clear there might be a problem here, Mr. Randall was terminated. All of Mr. Nelson's security staff has been turned over since 2011. There have been no incidents at Champions since last August. To briefly address the shooting that happened in August of last year, it occurred on a Wednesday night, when, but for the prohibition issued by Matt Clark, 2 off-duty officers would have been working outside Champions at 11 p.m. The shooter had a metal prosthetic leg. He was wanted at the door. The alarm went off. He pointed to his metal leg. He was allowed in. He was attacked by somebody else. He apparently drew a weapon and returned fire. One of Champion's 14 security cameras caught the incident on tape, and that footage led to the direct arrest of the suspect. Again, demonstrating that Champions has effective security. That's the way it's supposed to work. If somebody commits a crime, the suspect is apprehended with the cooperation of Champions. Champions has gone above and beyond by providing effective security at a very difficult corner. We've repeatedly asked that off-duty police officers be allowed to return, because they, more than anything else, are a very effective crime deterrent. We ask again that ban be lifted. As I've indicated, there is no record, there's no basis in the record to non-renew Champion's license. We do agree that the alternative course that the administrative law judge has suggested may be appropriate, the imposition of some or all of the conditions that she has suggested, including the return of off-duty officers working at Champions on its busiest night. And finally, the judge's final recommendation that bus stop be moved. The bus stop, as Mr. Nelson indicated in the spring of 2011, well before the undercover operation was launched, is the root cause of the problem, and the bus stop should be moved. Thank you for giving this case due consideration. As you know, the record is quite extensive. We request that you not rush to judgment and not make a decision today, but continue to take some time to analyze this very important matter. There are 25 jobs, $100,000 in sales tax, and $2 million of charitable contributions at stake. I have nothing else to do this afternoon but address any questions that the council members may have, and Mr. Nelson is here and makes himself available for that purpose as well.
Thank you, and thank you for taking off the rest of the afternoon. I assure you that probably won't be necessary, but I do have a few questions. First off, regarding to the bus stop, is it your contention that if the bus stop went slightly further down the road, half a block, then none of these problems would be happening?
They would be greatly reduced, and that is the testimony of all four. I didn't get into it in my primary remarks, but all four off-duty officers that previously worked at Champions before the prohibition offered by the prohibition issued by Inspector Clark testified that the bus stop is the problem, and if you move the bus stop, and Sergeant Schumer is on record stating this, and he was actually retaliated against by Inspector Clark because he told the truth to the press, and his quote is something to the effect of, if you get rid of the bus stop, you get rid of the narcotics problem. If it was moved down the street and not in front of a crowded parking lot in a very popular bar that's frequented predominantly by African Americans, yes, that would alleviate much of the problem. And the judge, administrative law judge, so found in her recommendation.
So, Mr. Matthews, is Mr. Matthews, right?
Yes, sir.
I mean, you do understand that there are numerous businesses all throughout the city that are closely situated to bus stops and or public transportation generally. It can't be I guess I don't understand how your contention that it's the bus stop in and of itself would eliminate.
Well, first of all, I don't expect you to take my word for it. I expect you to take the word of the four uniformed off-duty officers that worked at Champion: Sergeant Marvin Schumer, Sergeant Dennis Hamilton, Officer Troy Dillard, and Officer Dave Roiger.
And these are all individuals that are employed by Champions,
well, they
right?
were until
So
Inspector
if you
Clark
just
said
let me finish. These are all individuals that are employed by Champions, right?
They were.
And they get paid regularly by Champions, correct?
They were.
However, the insurance, if they are engaged in any sort of altercation, that would be subject to, the city would pay for that insurance, am I right?
That's a legal question I haven't had a chance to study.
Okay, well, I'm just making sure that the Champions is not paying for the insurance. Second off, are you aware of the facts relating to the revocation of the liquor license or the non-renewal of the liquor license for Gabby's?
I've read the case. It's a reported Court of Appeals decision, and the facts are very similar, where the city was seeking to hold a licensee responsible for the conduct of others. And that's what's at issue here, is that Champions has done nothing wrong. The allegations are that other people have done things wrong, and as you can see, they had to do things wrong off of Champions' presence because the very police reports relied on by the city established that the drug dealers did not want to be caught on Champions' property because of their effective security. Just coming back to the proximity of your question about if you move the bus stop and other businesses having bus stops in front of them, this is a very unique property. Without the opportunity to draw it on a map, I'll just explain that the bus stop is located very close to the front door, and it's a very tight area. And again, it's our contention, it has been all along, was Mr. Nelson's original suggestion and is the ALJ's recommendation that the bus stop simply be moved down the block to an area that is not so close to a very popular bar, frequented the majority of which by African Americans.
Councilmember Goodman?
Councilmember Frye, Mr. Matthews We don't have the power to move a bus stop. That's the Met Council through Metro Transit. Has your client approached Metro Transit about moving the bus stop?
He has repeatedly sought his city council member, Meg Tuthill's, assistance in this, and the administrative law judge heard extensive testimony on this, and she is recommending to whatever authority has the power to move the bus stop.
We're not the authority that has the power. Councilmember Tuthill doesn't even here anymore, and she doesn't have the power to move the bus stop either. I probably could give you 5 or more examples in my ward of locations where the bus stop is directly in front of an entrance to a bar or restaurant downtown. Those bars and restaurants don't seem to have this number of alleged and sustained complaints for bad conduct on premise.
All of that very well may be true, but the fact remains that Mr. Nelson brought the attention of the drug dealing and the gang activity to the city's attention proactively and wanted the city's help. What did he get in return? He was targeted in an undercover operation.
I didn't ask about your allegations of targeted and undercover investigations. I'm asking about the bus stop and whether or not you're aware that we don't run the bus stop. We don't run the bus company. We are not Metro Transit. And what did your client do to approach Metro Transit other than approach someone who isn't Metro Transit?
I don't think we have any evidence of that in the record.
Anything, nothing, right, okay. Mr. Fusey, I'm just inquiring with regard to this issue of off-duty officers. Do liquor license holders in the city have the right to hire off-duty officers in order to operate their businesses in a legal way?
Madam Chair and committee members, I believe the testimony in the record in this matter indicates that that's a policy that is entirely administered by the police department.
So no liquor license holder has the right to demand that off-duty officers work for them, correct?
Madam Chair, I would say that that is a correct assertion.
And then I'm wondering, Mr. Fusey or Mr. Matthews, for the $100,000 in sales tax that was generated, how much money was spent by the police department, the licensing department, and other departments of the city to regulate and or control the out-of-control behavior at Champions? I would guess it would be 10 plus times that $100,000 in sales tax that's been generated. So if the business were to go out of business, we'd be a net winner.
I disagree with that contention. It's not in the record, but I will use it to highlight the catch-22. One of the conditions is that Champions is required to follow, pursuant to the 2006 and 2007 licensing settlement agreements, which predated Mr. Nelson's ownership, but they require Champions to call 911. And when Champions does that, then those calls are used against Champions. It's a catch-22, and frankly, it's unfair. On the one hand, the city is saying you must call 911 to report crimes in progress, but when you do, those incidents go against Champions. And there was extensive testimony before the ALJ that there are all sorts of incidents, including speeding tickets and lost cell phones and everything else, lots of incidents that get attributed to Champions that are not Champions' responsibility.
Mr. Fusey, the findings of fact from the administrative law judge, however, do not cite the number of 911 calls as a reason for revocation, correct?
Madam Chair, that's correct, and I would advise the committee that that is not in the findings, and that is not one of the bases that staff is seeking this adverse action upon.
Thank you, Councilmember Frye.
Mr. Matthews, you would acknowledge that there were, I don't know, was it 20 to 40 some incidents that did take place on the premises?
No, I disagree with that number.
Okay. What is your contention as to how many there were?
It's in the single digits.
In the single digits. So in the single digits of instances, whether it was narcotics or pot smoking or shootings or assault, you're saying it's in the single digits?
It's in the single digits, and frankly, thank you for the opportunity to address, some of these. This marijuana incident, first of all, it's hearsay. There were some allegations in a police report written by an officer who did not testify in front of the ALJ and who I did not have an opportunity to cross-examine. It's hearsay. In many cases, we had statements being made by criminals to officers that were repeated in police reports. That's double hearsay, and that cannot form the basis for something as serious as non-renewal of a license action.
Are you aware of the rules of evidence in an administrative law judge in a law hearing?
I am very familiar, and I know that some reliable hearsay is admitted in administrative hearings.
Reliable hearsay is admitted, especially if it's from a principal that was directly involved in the situation, which would be so the case here. The standard in this particular instance is that renewal would not be in the public interest, and I would really emphasize that all businesses in our entire city are doing business with external factors that they can't control, and it is their responsibility to deal with those external factors and make sure that they don't become a problem to the community and the overarching city. So the question before us today is whether Champions has done an adequate job in dealing with those. And as we've had a settlement conference in 2006, settlement conference in 2007, we've had, I would argue that it's definitely in the double digits. I thought it was maybe 20 or 30 in total incidences that happened on the premises. Regardless of the external factors, and I do agree that there are some, these instances are repetitive.
We also had testimony during the hearing that the incidents that happen are typical of other bars and are not out of line in terms of severity or frequency with incidents that happen at popular bars in the city of Minneapolis.
That may be the case, with the exception of a few. I mean, there's only a few few bars that I can think of that have the chief of security soliciting prostitution, and even fewer that have a homicide that take place on the premises. And
I would agree, but we can almost be certain as we stand here today that many of those instances that happened since the spring of 2012 would not have happened if two uniformed off-duty officers would have been standing outside of the bar.
Has Champions ever thought about hiring a private firm to do any of their security?
We'd be willing to consider that.
Okay. They've never thought of it after the settlement conferences in 2006, 2007, and then
it's not in the record, but I can share with you that in the aim of reaching a resolution of this matter, it would be something that we would consider.
Do I have any other questions? Mr. Fuss, anything you'd like to add?
Mr. Vice Chair and committee members, nothing further to add from the city.
Well, I've read this record in extent. There are clearly external factors that I think are associated, and I do understand that, and I do feel for the business there. However, these are repetitive. They're over a period of 7 years at this point, and they've resulted in, I think, a danger to the patrons, a danger to the neighborhood, and I don't think any tax revenue generated would necessarily undo a homicide. These are major issues, and I would move to adopt the staff recommendation. All in favor? Aye. Oppose? Thank you.
Mr. Vice Chair, I would also advise the committee, based on that action, to adopt a separate motion directing the city attorney's office to prepare findings for the full city council reflecting your decision.
So moved. All in favor? Aye. Opposed? Yes.
To be heard on a request that the committee stay enforcement of the license denial pending certiorari appeal by the licensee to the Minnesota Court of Appeals. Pursuant to the case of DRJ Incorporated versus City of St. Paul, the court requires that a city council first consider a license holder's request for a stay of any adverse license action, such as license denial, prior to the court entertaining a motion for a stay made by the license holder. The standard that the appellate court requires a city council to apply when determining whether or not to grant a stay pending appeal requires the governmental unit to, and I quote, balance the license holder's interest in preserving the status quo so that effective relief will be available if the appeal succeeds against the interests of the public or the prevailing party in enforcing the decision and ensuring that they remain secure in victory while the appeal is pending. So at this time, it would be proper to hear briefly from the license holder's attorney on its request for a stay pending appeal, should it so desire to make such a request. And at the conclusion of that, I would request to be heard briefly in opposition to any motion. Thank you.
Thank you, Mr. Fussy. Before we move to the licensee, what's the period of time that it would take during the stay?
Well, Mr. Vice Chair and committee members, if I understand you correctly, this sort of action is appealable directly to the Minnesota Court of Appeals. There's not a set time as to how long such an appeal would take, but in my experience, it would take many months, and it could take over a year. However, I'll address all the factors that the city sees in terms of its recommendation on the stay after the licensee might make his case for a stay.
Is the Court of the Appeals the final decision maker?
Mr. Vice Chair, in this matter, in a standard appeal, it would go to the Court of Appeals, and then that decision could be appealed, discretionary appeal to the Supreme Court of the state of Minnesota.
Okay, and then the stay would continue throughout that entire period of time?
It could, and the stay could be managed or altered by the court throughout that time. And I do want to make it clear, the court will make the final decision on whether to grant a stay. It requires city councils to kind of weigh in and give their view on a stay. And in order to prevent this bouncing to them and coming back to you, we need to immediately address that today.
I guess I'm not sure I understand that.
Mr. Vice Chair, I guess what I can say is if we didn't consider a request for a stay today, it would come back to this committee within a cycle or two, and it would just delay things even longer, because the Court of Appeals does require that a city council in this situation give it a recommendation on whether it would grant a stay or not. And so it's proper for such a request to be made at this point and for this committee to consider whether it would recommend granting a stay.
Okay, and if we decided to or not to grant a stay presently, then that decision would not come back to us throughout the entire stay period?
Mr. Vice Chair, most likely not, unless there was some extreme change in circumstance.
Okay. Thank you, Mr. Fussy. Mr. Matthews.
Champions requests a stay. As the council members know, the administrative law judge in the alternative recommended that certain conditions be imposed on Champions. That reflects her judgment that the continued operation of Champions is not so detrimental to the public interest that it needs to be have its liquor license non-renewed immediately. The case that Assistant City Attorney Fussy has cited, the DRJ case, indicates that the factors to consider are whether, number one, the imposition of operating conditions could adequately protect the public, and also a consideration by this subcommittee as to whether the licensee has adhered to operating conditions in the past. Both those factors support the granting of a stay in this case. Certainly, operating conditions that would protect the public are certainly implementable here and could certainly be adopted by this city council. And I just note for the record, there have not been any incidences of violence or other disturbances since last August. Champions is continuing to operate at the highest level of security. As I indicated, all of its security staff have been turned over since 2011, and Champions continues to have a very safe and effective atmosphere. So the imposition of conditions could certainly protect the public interest. I also note that Champions has complied with previous conditions that have been imposed by the city, including calling 911 when requested, even though it knew that those 911 calls would be used against it in licensing proceedings such as this one. And I also note that Mr. Nelson has not been convicted of any offense. He's law-abiding and is certainly respectful of the city and will follow any conditions. Obviously, the immediate non-renewal of its liquor license would have an incredibly detrimental impact on Champions. People would migrate other places. The melting pot that is Champions would be lost. I also note for the record that this same subcommittee and the city of Minneapolis took similar action against Gabby's. And that case was appealed to the Court of Appeals. It was also the subject of federal litigation. The Court of Appeals reversed the city's decision to impose conditions on Gabby's. And the federal lawsuit was settled by the city paying over $200,000 to the city of Minneapolis. I expect, given the subcommittee's decision today, we're going to have the same sort of litigation, and we certainly anticipate, in all due respect, an appeal to the Court of Appeals. So I think it's in everyone's best interest from a continued operation in a monetary standpoint that could someday be a judgment or a settlement from the city to maintain the status quo while Champions appeals to the Court of Appeals.
Thank you, Mr. Matthews. I'd like to, I guess, add two things. First, I've also read the Gabby's case, and I think there are pretty serious differences. Second of all, I'm sure you're aware, but the licensee in all circumstances is subject to vicarious liability. So regardless of what they themselves or the owner or the owner's honor or commitment did, they are still vicariously liable for whatever happened on the premises, and that equals inside as well as in the parking lot.
I respect, I mean, not to belabor this, but I respectfully disagree with that. City Ordinance 259-250 requires the licensee to take action to prevent further violations, and Champions has done that by trespassing and keeping persons off its property, and they have met their obligation in that regard, and I note that for the record.
Councilmember Goodman?
Mr. Fusey, what is your point of view with regard to the stay issue?
Thank you. And on behalf of the Licensing Division and the Police Department, I would urge the committee to deny the request for the stay for the following reasons. And initially, Mr. Matthews referred to the ALJ discussing some possible conditions in her report. I would note that that was the city's fallback position in this case, and she only addressed that. She clearly said that the city had the operation of Champions was not in the public interest, and that the city had the ability to deny the licensure of Champions. She in no way recommended that conditions be imposed. And secondly, the remaining reasons would be the past history of the establishment, which includes an unprecedented 2 previous license settlements involving adverse license action, suspensions and fines for illicit narcotics transactions. I would also note that the ALJ report is extremely detailed, well-founded, and very conclusive in that the establishment is not serving the public interest and that continued licensure would not be in the public interest. And therefore, this public interest analysis in conclusion is crucial to the determination of a stay request based on the applicable standard from that DRJ case, which explicitly makes the ongoing public interest a determinative factor in any stay analysis. And if you look at the severity, quantity, and extent of the identified issues going forward, the ALJ concluded that this establishment is not operating in the public interest, and it's not I guess, beneficial to the public health to allow the establishment to remain open for an appellate period that could stretch many months and could stretch over a year. And I think this is important as well. I think the license holder has continued at all stages in this proceeding to steadfastly refuse to accept any responsibility for the criminal and nuisance activity that has occurred and reoccurred and escalated in and on its premises, instead pointing the blame at the police department and claiming to be the victim of some sort of grand conspiracy and targeting scheme. This posture belies any real possibility for the establishment to be operated in a manner that would serve the public interest and not result in a continuation of the documented history of detrimental criminal and nuisance activity in and on the premises. Quite frankly, the operation of this establishment has resulted in multiple felony criminal violations. It has resulted in large fights. It has resulted in shootings, and it has resulted in a homicide inside the establishment. To allow it to stay open during the pendency of an appeal when I think the decision is so conclusively in favor of allowing for denial of this license would not serve the public interest. And for these reasons, I request that the committee deny the stay request.
Thank you. Do you have any further comments, Mr. Matthews?
Yeah, tons. I mean, there's so much that is wrong with that. Mr. Nelson takes responsibility for his premises. That doesn't change the fact that he was the first one to alert the city to the drug dealing, and then that communication was used against him by this undercover operation. Mr. Nelson takes incredible pride in the security that he provides at his establishment on a very dangerous corner without any help from the city, and frankly, with the city's resistance and the withdrawal, the outright withdrawal of off-duty police officers. And to suggest that Mr. Nelson takes no responsibility, it's simply not right. And throughout this proceeding, Mr. Wilson and Mr. Fussy have continually cited these 2006 and 2007 settlements where Mr. Nelson, in one of those cases without counsel, agreed to certain terms and conditions, and then that is used against him in a later proceeding, namely this proceeding. So if we had willy-nilly just simply agreed to some conditions in this case, it would have made any further proceedings down the line that much more difficult. The bar owner certainly has rights, and the truth will set you free. And in this case, Mr. Nelson has gone above and beyond to provide adequate and above adequate security in a very troubled location. He is very respectful of the city. 4 officers testified that their presence reduced crime. And despite that, Inspector Clark removed off-duty officers and weakened the security situation. We'd like to have off-duty officers back. We'd like to implement some of the conditions that the ALJ has outlined.
Mr. Matthews, when were the off-duty officers taken away?
March of 2012.
I think you mentioned that the last several months there's been a decline in the number of instances.
Because Mr. Nelson has hired very good, top-notch private security.
So they have
that are not off-duty police officers.
Councilmember Goodman.
Thank you, Mr. Chair. I'm going to move to deny the stay. I'm a little bit distraught to hear you describe this as a dangerous corner and a terrible part of town, but you had nothing to do with that. Just happens to be that it's an awful area with lots of minorities, right? Lots of people using that bus stop, lots of people of color who frequent this business, and they happen to be bringing in all of this trouble. I cannot imagine being a neighbor to this and not think that this is not in the public interest. People who live immediately adjacent to this, and there are a lot of them.
It's a commercial area. With all due respect,
there's a public housing high-rise pretty much directly behind it, and there is at 28th Street, there's quite a bit of housing. So it's a commercial street with plenty of housing surrounding it, and I don't think those people think they live in a dangerous neighborhood in a horrible part of town. The criteria, as I understand it, are there operating conditions that could protect the public? And if there were, why didn't you use them before there was a homicide in your establishment? I don't believe you have any intention of doing anything other than blaming the dangerous location, the awful people at the bus stop, the city for not controlling Metro Transit. There's an excuse for every one of these things. The pot smoking, well, that wasn't pot smoking.
What would you like Champions to do?
My point of view with regard to this is that this establishment having a liquor license is not in the public interest, and I don't believe we should be issuing a liquor license in this location, and I believe the findings of fact support that, and I'm asking the chair to call the question on staying giving the court our advice not to stay the order.
So I'll move to deny the stay. All in favor say aye.
Aye.
Aye. All opposed? Thank you, Mr. Matthews.
And Mr. Vice Chair, the one final thing would just be simply, I would advise you to direct the City Attorney's Office to draft findings supporting your denial of the stay request.
I'll make that direction. Do I need a motion for that?
We might as well do a motion.
Okay.
just for the
All in
record.
favor of directing the staff to draft some findings up, say aye.
Aye.
Opposed? Thank you. The next item on the agenda is number 4. Okay. So this is also a quasi-judicial hearing, and the same aspects regarding not including any additional facts apply in this for item number 4 as applied in item number 3. We have
Cynthia. This is your last time doing this kind of work in front of us, and someone else is going to be taking over. Perhaps we could thank you for all the work that you've done, and maybe you could introduce the person who might be doing this going forward today as well.
I would like to introduce Christina Dowling, who is a legal coordinator with Regulatory Services, and she'll be representing the Department of Reg Services instead of me, moving forward.
Thank you, Cynthia, and
Christina's
thank
here
you for your
today
work.
to- Thank you very much. The property involved in today's hearing is located at 3511 Colfax Avenue, north of Minneapolis. The property is a single-family dwelling. The owner of the property, Covenant Line, Inc., is represented by Mr. Alan Zack. Mr. Zack obtained a license to operate this single-family dwelling as a rental business in April of 2010. He named Scott Zack as his agent of record. In May of 2011, an inspection occurred at the property. At that time, the inspection revealed a basement room being used as a bedroom. The room did not have proper egress windows, nor was the ceiling height meeting code of 7 feet. The dwelling was posted as unlawfully occupied, and the room was to be vacated by June 1st, 2011. Notice of the violation was issued. Director's determination of noncompliance for unlawful occupancy was also issued. Upon reinspection in June of 2011, the property was found to be vacant. All bedding materials had been removed from the basement, and the order was closed as abated. A second inspection occurred in September of 2013, and at that time, 2 rooms in the basement were found to be used as bedrooms. Neither room had egress windows, nor was the ceiling height up to code 7 feet. The dwelling was posted as unlawfully occupied. The rooms had to be vacated by October 1st, 2013. When the inspector returned on October 2nd, 2013, the order had not been complied with. A $250 administrative citation was issued, and upon reinspection October 17th, the property was then found to be vacated and the order was closed. On September 16th of 2013, a notice of revocation was issued to this owner for allowing the property to be illegally occupied twice. The owner was given a 15 days to file a written objection, which he did. And on January 9th, 2014, before an administrative hearing officer, testimony was given by both parties. The hearing officer's findings were to recommend revocation. However, he stayed that recommendation for 1 year on 5 specific conditions. The first condition was there was to be no illegal or unlawful occupancy at the property. The second was that the owner was to pay a $2,500 fine by January 17th of 2014. The third condition was the owner was to provide a copy of any future lease which shows language prohibiting the use of the basement rooms as bedrooms. The fourth condition was the owner was to comply with any outstanding orders in a timely manner and by the due dates given. And the fifth condition was that the owner was to maintain the basement rooms in a manner as to not encourage their use as a bedroom. A review of our department records on February 7th, 2014 indicated that the owner has failed those conditions. Therefore, the city is asking that we move forward to revoke his license to operate.
Thank you, Cynthia. Do we have any questions? I just have a couple real quick. So has the $2,500 fee, has that been paid?
No, it has not.
Okay, thank you.
Is that the only one?
Is that the only fee?
Is that the only?
When the inspector reviewed the records January 9th, they didn't actually conduct an inspection at the property. The outstanding order had previously been complied with October 17th. The property was vacant. So the owner is to provide us with a copy of any future lease with that specific language in it if he was going to allow it to be occupied. And there was also to be discussion on how to make these rooms not appear to be bedrooms. And part of that discussion was held with the inspector after the hearing.
So you say it's presently vacant?
The last time the inspector was there was October 17th. And until it can be occupied, he has to provide a copy of the lease.
Thank you. Is the representative from the licensee here, or from the owner? Yes. Please. Thank you, Cynthia. Good afternoon.
Good afternoon.
Please state your name for the record here.
Scott Zach.
Thank you, Mr. Zach. Zach?
Address for the record.
Correct. ZAK.
Yeah, can you give us your address too, please?
My personal address?
Yeah.
2300 Jarvis Hills Drive, Little Canada, Minnesota, 55117.
Thank you. Give us the rundown on your side of the story, please.
Cynthia summarized it well on both occasions, in no denying that there was illegal occupation of the basement bedrooms. However, under the lease, it was noted at that time that they were not to occupy them. And the people that were occupying the basement bedrooms were not under the lease, and they were not approved to be there. Under both circumstances, we took action immediately. And the second time, the first time they vacated immediately under violation of the lease, and the second time the tenant did drag their feet, and it took them extra time. Their lease was up September 30th, and they were supposed to be out by that time. As Cynthia stated, the occupant was still there on October 2nd, and I believe it was October 7th before they finally moved out of the entire home. They did vacate the basement bedrooms on October 2nd by that afternoon, when Inspector Roski came back and viewed the property. It was our understanding that we would receive notice of the items that we had to fulfill after the hearing. We waited a few days, in fact weeks, to receive that. Nothing was received by mail, as it was stated by the attorney that was present that day. And the most recent notice we got was the notice for this hearing. So that's why we're here today, just to reconsider that. And I won't maybe waste too much time with kind of the background of how we ended up with the property and all we've done to, I guess, get it through code compliance and spend a tremendous amount of money on that to not lose it to, I guess, the recession, et cetera. But in all circumstances, when violations have been cited, we've addressed them immediately and take it very seriously, especially the safety of the tenants. In the most recent citation of illegal occupation of the bedrooms, they once they did move, we did pull permit to have an egress window installed, knowing that that simply alone wouldn't allow for a basement to necessarily be approved, but really for just to have safety of future tenants in mind. So that we have done. We would like to get variance approval for the ceiling height. 7 feet is the cited need. We were at 6 foot 11 inches there. So there's I guess a realistic possibility of that happening. And we would consider doing the recommendation of the city, of the council, and through the regulatory licensing agency to do what's requested.
Have you paid the $2,500?
No, we haven't. Again, we thought we would be getting notice of the items to be completed. It was understood that day when it was supposed to be completed or paid, but again, not to who or where and how to do that. It wasn't that day, and again, just was looking for something by mail or some correspondence to instruct us on how to do that.
Councilmember Goodman.
Mr. Zach, the property's not occupied, correct?
It is currently occupied, yes. Yeah, it was rented as a 3-bedroom home, and it was our understanding through Inspector Roski that was allowed, as this is a pending issue.
Well, I guess I'd have to ask our staff. The 5 conditions that I saw were that you weren't allowed to occupy it until you had a lease that showed that you weren't going to be using the basement units.
I did supply a lease noting the itemized line item that they were not to occupy it. It detailed how many bedrooms the home is and what areas are allowed to be occupied and what can't be allowed in the basement.
Cynthia, I'm confused as to whether or not he's in violation or not. You're about to lose your rental license.
I understand that.
It's a big deal.
It's a very big deal.
And I fail to understand how they could tell you in a settlement conference, these 5 things have to be done, and your response was, well, they didn't send us another letter telling us these 5 things need to be done, and we don't know who to make a check out to the city of Minneapolis and send it where?
Correct.
Do you want a rental license at this business?
Of course.
Okay, then why didn't you follow the 5 things that came from the administrative law judge? They seem pretty clear to me.
We did.
Cynthia, can you clarify for us exactly? Please step forward. I wrote them down, actually. No overoccupancy, pay the fine, give a lease copy, fix all existing orders, and the basement, they have to stipulate that the basement will not be used for a bedroom. Those were the 5 things that came out of the decision of the administrative law judge. Is it our process then to send them a letter confirming what happened from the administrative law judge?
This actual recommendation, Your Honor, was signed by the hearing officer on January 31st, 2014. The actual draft findings were prepared after the hearing. However, the respondent was present in the room. It was very specific, the 5 items that needed to be done, and it was part of the oral testimony.
Okay, so Mr. Sack, you were there. They told you the 5 things to do, including paying the fine. Why didn't you do it?
We did those items. The only thing we haven't done at this point is pay the fine of $2,500. In receiving this notice, it gave us time to reflect on, I guess, the excessive nature of that fine as well. So we'd like to actually contest that and ask that that be.
You're about to lose your rental license. You understand that, right?
I do understand that.
Okay.
Yes.
Mr. Fusey, do you I'm looking to help you, but you're making it impossible for me to help you. Mr. Fusey, perhaps you could give us some direction here. It sounds like they went to administrative process. They agreed to the conditions and signed them. The conditions are not complete. They're still occupying the building and leasing it. Is any of this allowed?
Madam Chair, I wasn't a party to this hearing, but from my understanding of what I've heard here today, he hasn't complied with the conditions, and that's what we're here for, the fact that he hasn't complied with these conditions. And certainly the committee, if they wanted to give him more time, could do that, but you're under no obligation to do that. The fact of the matter is that it appears that the evidence indicates that he is in violation of the rental licensing standards.
So, Mr. Fusey, I think one of the clearly undisputed issues is that they have not presently paid the fine of $2,500. What would be the procedural mechanism by which we could not revoke the rental license, allowing him to pay the $2,500 by the end of the day today?
I think you could forward the matter without recommendation, and then depending on what happens in the interim at the full council or at committee of the whole, a substitute motion could be made either to pull back the matter or to proceed with the revocation.
And so the mechanism would be forwarding?
You would move to forward the matter without recommendation and instruct that if the condition was complied with, you would be amenable to not revoking his license once it comes to the full council next week.
Okay. So it's 2:48 right now. Yeah, you go to the U.S. Bank generally? Or Wells Fargo?
I do not, no. No, and
What's the bank
I should
doing?
clarify that I own this with my father.
Okay, sure.
Who doesn't live in town, so I'd like to discuss, I guess, what's discussed here with him as well. And I guess consider our options with that. Secondly, if this is in place and our, inability to pay that fine, if it won't be reconsidered, our only other option is to sell the property, which I guess is our second option, but we're here to kind of realize which direction to go with this.
For the $2,500, you would sell the property?
Yes, sir. That would be our only option.
Councilmember Wright.
Thank you, Mr. Chair. And this is just me opining to the group. I don't think we're here to negotiate that part of it. We're here to, and I think Councilmember Goodman's being very generous to look for ways here, and we've kind of found a path that doesn't guarantee. I think the word was amenable to the consideration of the full council. I think that's the opening that we're offering. That's rather generous.
Councilmember Goodman?
Do you have anything else to add to try to convince us to allow you to keep this license?
Well, again, I would just reiterate that the people that occupied the basement bedrooms of this home were not tenants of ours. We did not know they lived there. We did not know who they were. They were not our tenants in both circumstances. And we took immediate action when we did find out that that was the case.
Okay. Do you have anything, Cynthia, you want to add?
I do not. You know, I believe that the hearing officer's decision on the record was an attempt to place conditions on this owner to allow him to keep his license in good standing, staying it for a year with those conditions, rather than immediately recommending revocation. And the fact that the conditions have not been met, that is why we're here today.
Okay. Thank you.
Thank
Mr.
you.
Chair.
Yeah, at this point, we are not negotiating on the fine. At this point, I would ask you, direct you to call your father, have the discussion, and then, go downstairs and across the street and go to the bank. And if you can get the $22,500 by the close of business today, then, we'll make the motion right now to forward this matter to the full council, assuming that the $2,500 has been paid. I would move that we forward the matter. If it hasn't, of course,
I'll help you.
it would be revoked.
Okay. So I'm going to make a motion. I'm going to make a motion to move this forward without recommendation. We're going to give you till the close of business to pay the fine. We're going to give you till a week from Thursday to tell Cynthia that every one of these other conditions were met. There will be no more hearing in front of us. So what will happen from here is if you pay the fine and meet these 4 conditions, by a week from Friday, you will get the license renewed. If you don't, you will not. And that will be it, and I'm going to guess you'll have to almost immediately vacate the unit. We almost always revoke these licenses. We are looking for a way to help you keep these tenants in the building. I would urge you to do your part, or it will be over, because you won't be in front of us again. The next time you hear about this, the whole council will be voting.
Would tomorrow, end of business day tomorrow, to pay the fine be okay?
I can agree to that. Can you all agree to?
Tomorrow and a business day for the $2,500.
2,500?
As well, I will agree to that. I'm going to move that you have until the end of business tomorrow to pay the fine. You can have a chance to talk to your father about it or not. But by a week from Thursday, you need to finish up these other 4 things too. It sounds like you're making some progress, but I need to hear from our staff. All of these, don't make me take off my glasses again, all of these 4 other things have been addressed to their satisfaction, and you should realize we are cutting you a lot of slack here. I almost never would do this. I feel like you've tried kind of hard, and then you've ignored some of the other pieces of it. Get it resolved, man, or you're not going to have a rental license here.
The other 4 items are complete. And I'll
Okay,
get
but I
that
want to hear it to
Cynthia as
our
well.
staff's satisfaction. So you have one little thing, I would take care of it if I were you.
So there's been a motion. All in favor, say aye.
Aye.
All opposed? Back to Chair Goodman.
Are there any other items or issues anyone would like to discuss? Everything else on the rest of the agenda has been commenced. Seeing no further business before us, I'm going to call on Mr. Fusey just to give us some advice with regard to the quasi-judicial action and our ability to talk to or not talk to members of the public and or the media with regard to the actions taken today. Mr. Fusey.
Thank you very much, Madam Chair and committee members. I do want to take the opportunity to reiterate, obviously, the issue at number 3 on the agenda today is a complex one, and it involves a pending quasi-judicial matter, and it also involves current litigation against the city. And because of the confluence of those 2 things, it certainly would be my office's advice that in order to remain in compliance with your requirements under quasi-judicial matters and also to protect the city in the litigation, that no public comments or media comments be made regarding the specifics of that matter, and that we let it run its course. Thank you.
Okay, so I would direct that to mean forward comments from the media or constituents to our attorneys. Seeing no further business before us, we are adjourned.